Go ahead and call the July 25th, 2011 Salina City Commission meeting to order. Madam Clerk, will you please call the roll?
Mayor Angel.
Here.
Commissioner Crawford. Here. Commissioner Householder.
Here.
Commissioner Jennings.
Here.
Commissioner Shirley. Here.
Will you all stand and join me for the Pledge of Allegiance and a moment of silence? Turn that off.
What is that?
Oh. Got an idea?
Oh, now you've done it.
You may want to just turn it off. I don't. It's. Oh,
Where it went. It's okay.
you stand down there, Aaron. If you stand down there. The first thing on our agenda is the Citizens Forum. It's a time for any member of the public to talk about any items not on today's agenda. Come on up to the podium. Give us your name and address. Yeah, it's back.
There you go.
We will move on to awards and proclamations.
Item 4.1, presentation of the Patriot Award to Martha Tasker, the Director of Utilities.
I don't have anything on that. Mr. Gage, are you handling that? Who's handling that? Come on up.
I'm Kirby Sullivan. I'm with the Employer Support of the Guard and Reserve. I'm basically a volunteer. I work at Schwann's plant. And what the Employer Support of the Guard and Reserve does is three things. We work with service members and employers, make sure they're communicating with one another. We also recognize people that have been supportive of their service members. So that's really what I'm here for today to do. And that is to present a Patriot Award to Martha Tasker that was nominated by John Rose. And what I'll do is I'll just read the nomination, Martha, then share the award with you, and at the end I'll ask you to sign a statement of support for the Guard and Reserve. Here's what John said. I'm nominating Martha because she has been very supportive and understanding to both my wife, Melissa, who works directly for Martha, and myself. I work for Martha's department in water distribution. Martha has been very supportive of the Kansas National Guard and me as a member. She has been understanding and supportive to my wife when needing to take time off to take care of our children while I was deployed, and has worked with her scheduling to make sure she had adequate time to take care of things at home. I understand that this is something you probably look at and say, what's the big deal? And in reality, many employers are very supportive of their service members as well, but not everybody. So we want to take the time to provide you with the Patriotic Employer Award. Office of the Secretary of Defense, Employer Support of the Guard and Reserve, recognizes Martha A. Tasker, City of Salina, as a patriotic employer for contributing to the national security and protecting liberty and freedom by supporting employee participation in America's National Guard and Reserve Force. That accounts for about 50% of our service deployed now. So, Martha, I'd like to present you with that.
Congratulations. You have a speech. Come on up.
I appreciate receiving the award very much. As mentioned, John and Melissa both work in my department, and I would say that I probably asked Melissa to stay late more times than she's asked me to adjust her schedule to be home to take care of the children or her home. So I think that goes both ways. Thank you.
Thanks, Martha. Congratulations. Move on to public hearings and items scheduled for a certain time.
Item 5.1, public hearing on an appeal on the conditions of approval applicable to application CU 09-1, requesting approval of a conditional use permit to allow the expansion of an auto salvage yard in an I-2 district.
Mayor, I'm going to need to probably recuse myself at this point because of my prior involvement with the Planning Commission on this issue.
Thank you, Commissioner. I also have a conflict of interest and need to recuse myself, and I'll let Vice Mayor Jennings open the public hearing.
At this point in time, I'd like to open the public hearing on item number 5.1. Will be Mr. Andrews.
Thank you, Vice Mayor and Commissioners. We'll give you a little brief overview of what brought us to this public hearing today. Mr. Hers has some graphics that he'll display for you on the screen, but just for everyone to get their bearings. At the bottom of the screen is West State Street. At the right-hand side of the screen is Cherry Street, which extends north from State Street. The area highlighted in yellow there are new properties which BFR Metals or Bone Farm and Ranch purchased within the last 10 years to add space to a salvage operation that used to exist out there under the name of Wooster Auto Salvage. So that particular space was grandfathered in, and then there were two acquisitions made. This property from Lonnie Wilson and this property from Randy Sterrett. And the plan was to expand the salvage yard operation out in that location. So in the meantime, the City Commission was looking at the both the zoning ordinance and the chapter that dealt with the licensing of salvage yards and reviewing those standards that applied. So this was one of the sites that we were working on to bring closer to compliance to the expectations that the City Commission and Planning Commission had for salvage yard operations. So as part of that, a conditional use permit was applied for those areas enclosed in yellow in 2009. That was filed in March of that year. There were multiple Planning Commission hearings, one of which focused on whether a gate should be permitted on Cherry Street. And eventually, on May the 5th, 2009, the Planning Commission voted to approve a plan for expanding the auto salvage into this area here. And so the plan that you see, this dashed area there, is every salvage yard operation is supposed to have a fire lane that extends through that property that's an all-weather surface that fire trucks or ambulances can count on being clear and count on having a hard surface there for them to drive on to respond to any kind of emergency. So this represents a gate on State, a gate through Mr. Wilson's property with a gate here, and then a plan for a gate on Cherry. This little area that you see hatched there is an area that was just dirt and mud and had no gravel surfacing whatsoever, and that surfacing needed to be extended to get to that gate. So the Planning Commission voted 6-1 to approve a conditional use permit under that plan. And although they discussed the condition of Cherry Street and the use of that gate in their action on May 5th, 2009, they did not incorporate any specific condition that dealt with the use of that gate. In response to numerous complaints received in the first part of this year, the Planning Commission reconvened a public hearing in March 2011 to review the conditions of approval and use of that gate. And these are some photos that were taken at that time. This is the north end of Cherry Street. This is the Cherry Street such as it is, and the entryway into that location. I think we have, these are photos that the Planning Commission reviewed at their March 11th hearing. This is looking west into the gate that comes off of Cherry Street. And that is across the street on Mr. Young's property looking that direction. After hearing comments from staff and property owners on Cherry Street that felt affected by what they viewed as a change in traffic patterns, the Planning Commission voted 7-0 to add a condition to BFR Metals conditional use permit and limiting the Cherry Street gate to emergency vehicles only. The Planning Commission's belief was that no matter what kind of upgrades were made to Cherry Street, that surface that was there would not be able to accommodate the kinds of heavily loaded trucks that we're talking about. I think we may have a closer photo than that, Dustin. That has the truck. Maybe it's towards the end. This is the type of vehicles that we're talking about in terms of coming out of the gate during that period of time in January and February. So essentially what the Planning Commission did was limited commercial truck traffic visiting BFR Metals salvage yard to entering either on State Street or through the gate on Mr. Wilson's property, but using this gate only by City of Salina emergency service vehicles. Before the 14-day appeals deadline fell, an appeal was filed by Terry Criss, attorney for BFR Metals, and this item was placed on your agenda. But in reviewing that on May the 9th, you determined that you felt you needed additional factual information about how the Planning Commission reached the decision that it did, and so this was sent back to the Planning Commission. They met on June the 2nd and had a special meeting and reviewed all the DVD recordings of the previous hearings. They held 2 closed sessions with the city attorney, who helped them prepare the findings and conclusions that you have attached to your report. And those findings and conclusions go into detail on what factors they considered in reaching their decision. So they approved a motion at their last meeting, July 19th, adopting those findings that you have attached in support of their March 15th action. And again, those are attached to your report. So your options this afternoon would be to accept those findings and sustain the decision of the Planning Commission relating to the use of that gate on Cherry Street. You could return this item to the Planning Commission if you feel like there are still some gaps in the information, or you would like additional information before reaching a decision. Or you could concur with the applicant's attorney that the Planning Commission lacked the necessary factual basis and authority to modify the conditions that they had originally enacted. This is a quasi-judicial matter. The Planning Commission's information was prepared with the assistance of Mr. Bankston and myself, and certainly free to ask us any questions if you need clarification about those items. But your role today is to weigh all the evidence and to reach a conclusion at what's in the best interest of the community. So with that, I'd address any questions you have about anything that was in your packet, or if you have questions about findings of fact, I might defer those to Mr. Bankston.
This time I do not. Either commissioners present?
No.
Thank you.
Matter of protocol from here.
Yes, Vice Mayor, I think it would be good to call upon Mr. Chris and his client are here. We certainly want to give them opportunity to make any presentation they might wish to you. As Mr. Andrew explained, my role with the Planning Commission was to try to assist them in capturing their thoughts, both in terms of the factual findings and the conclusions that they reached. So I stand ready for questions at whatever time that's useful.
Very good, thank you. I would like to turn the matter over to the attorney representing the claimants.
Thank you. I was here several weeks ago. I believe Mr. Andrews said it was May 9th that we were here on this matter before. And at that point in time, the City Commission did something that sounded fairly simple, and that was they asked the Planning Commission to say what findings of fact we made and what conclusions of law did we have. What were we thinking, in effect, when we made this decision on March the 19th? What is it that we were thinking about? It took them 3 meetings to figure out what they were thinking about. They didn't just review what they talked about on March 19th. They backed up 2 years, and they reviewed all the public hearings. They reviewed things that did not come before them on March 19th. They reviewed things that did come before them on March 19th. If you look at the proposed findings, those proposed findings that they've come up with even include comments that came up on July 19th, the same day that they adopted their proposed findings. So they were exercising some degree of clairvoyance there, thinking ahead that on March 19th, 4 months later, they were going to be able to know what they were going to see and hear on July 19th. What that all points to is that there was a mistake made at the Planning Commission level. As we argued when we were here a couple of months ago, the mistake that's been made is that the Planning Commission has taken action which it has no lawful authority to take. In April of 2009, they took under consideration an application for a conditional use permit. They held at least 2 hearings, I believe it may have been 3 hearings where people could come in and talk about the conditional use permit. Staff was there, they reviewed it, they discussed it. They talked about the Cherry Street gate. If you look in your packet, you've got the original application, the original site plan in there. The site plan shows a Cherry Street gate. If you look at the description of the property as it is proposed for the conditional use permit, it talks about access to the property through Cherry Street. It's in writing, it's in the application, it's in your packet, it was before the commission. At that point in time, the Planning Commission certainly could have attached a condition to the use of the Cherry Street gate. They discussed it, but they did not do it at that time. Nor did they reserve the right to do so 2 years later. There's nothing in the ordinances in the city which would allow them to take that action, and BFR Metals would contend that that action is unlawful and is taken wholly without any authority. Their proposed findings of fact and conclusions of law don't address that at all. That isn't something that they thought of. They didn't consider the landowner's rights when they met and put these additional conditions on. They didn't consider the fact that 2 years has elapsed since that conditional use permit was done, and there's been a business built up on those tracts that were acquired that Mr. Andrew pointed out on the east half of the north part, or the east 2/3. They didn't consider how the business had operated. They didn't ask about the flow of circulation within the business. They didn't ask the BFR Metals, what impact would this have on your business if you didn't have access? How do you think in the long run this is going to affect you? I think submit to the commission that what they have come up with in proposed findings and fact and conclusions are written simply to justify action that they took on a looking backwards basis rather than anything that they considered while it was actually in front of them. Now, In the appeal letter, which was written on March 29th, there's really no sense in me standing here and reading it to you. It's in your packets, and you can review that. But certainly would want to emphasize again that it is within their power to have put conditions on that conditional use permit at the time it was adopted. And in fact, there are conditions on that conditional use permit. Those conditions have been met. If the city came back and said, well, we're going to take action against you because you haven't met existing conditions, then I think BFR Metals would have something to talk about with the commission in terms of what they were going to do to come into compliance with the existing conditions. But having had the opportunity to make conditions and having failed to do so, and indeed having failed to do so on a matter which was before them and which was discussed by them, they've lost their chance to do that. There's nothing in the ordinances of Salina which now allow them to go back and put in those additional uses. Additional restrictions, excuse me. The impact of that is one that will cause monetary loss to BFR Metals if the decision of the Planning Commission is allowed to stand. And I don't think that's anything, given the current budgetary constraints, that the city wants to see. It's certainly nothing that BFR Metals wants to see. They're here in Salina. They're trying to run their recycling business in a profitable and an economic way. And just like all the other businesses in Salina, their goal is to make a profit and to stay within all the restrictions that are lawfully placed on them. We believe they've done that, and we believe that the Planning Commission's action should be overturned. Are there any questions I could answer for the commissioners?
Commissioners? None?
No.
None, thank you.
Thank you.
Vice Mayor, if it would be appropriate at a time in your deliberations, I would appreciate the chance to speak with you briefly in executive session.
Yes. About how long would our executive session?
I would think 10 minutes would suffice.
Vice Mayor, I move to recess into executive session for 10 minutes to discuss with legal counsel matters subject to the attorney-client privilege for the reason that public discussion of those matters would waive the privilege and adversely affect the city's interest in the matters, and reconvene at 25 minutes till 5.
Excuse me, Commissioner, if I may, could we also note, and I apologize, I didn't mention this in advance, that as part of your motion, this is also in your role in a quasi-judicial function that you would be lawfully able to consult privately for that purpose.
And you want that in the motion?
Well, just that the along with consultation with legal counsel, it would also just be in your quasi-judicial role relative to this matter.
Okay, and this would be in the quasi-judicial role as commissioners, is that?
Correct. Thank you.
Second.
We have a motion to move into executive session. All those in favor say aye.
Aye.
Those opposed? We are in executive session. Shall return at 4:35. I'd like to call this July 25th session back in and reconvene our public hearing, reopen our public hearing. At this point in time, Mr. Bingston, I would like for you to present on this matter.
Okay, thank you, Vice Mayor. Just a point of clarification as to the process. Certainly, you all directed the Planning Commission to make a determination as to their findings and conclusions as the basis for their original decision. And in response to that, the process that ensued was certainly carried out on the basis of my recommendation. And that had to do with the fact that it is an important matter. It's an extremely important matter. And we were responding to a suggestion by the business owner that we, in our regulatory role, in their opinion, had taken action constituting a taking of private property. That's an important matter. We take that seriously. We generally try not to do that. In carrying out the city's regulatory role, it's important, and there's certainly applicable law. It's my opinion that the matter of the taking, or even just the question of the lawfulness of the Planning Commission's decision, as I tried to relate back in that meeting, was sufficiently factually based that it warranted the Planning Commission articulating that basis in a way that you could then fulfill your responsibility as you considered the appeal. I advised the Planning Commission that in doing so, and going through the process, if they reached a different conclusion, they should feel free to reach a different conclusion. There's no question. They did look further and in more detail, went back to those, to viewing the tapes of those original hearings at my recommendation, and certainly appreciate that they did so. I think it enabled them to look at the history of the matter and determine far more precisely the factual basis and the reasoning behind the decision that they reached. Now, they happen to reach the same conclusion, and that just happened to be the conclusion they reached. It was not without certainly thought and consideration. So that brings us to the discussion here today. I want to make just quickly the public statement that in one of the points wanted to assure you all that you are at a level where you, as the City Commission, have full and complete discretion on this matter. And we have been through the process. The statutory process anticipates that the matter be returned potentially to the city or to the Planning Commission. We've been through that process, and having done so, you are now in a position to either concur with, overturn, or reach whatever conclusion you believe is the correct conclusion under these circumstances. So that's what brings us here today. And as I said, if there are any further questions or any other public input, I'm sure you'd want to consider that before reaching your final conclusion.
Are there any questions for Mr. Bankston at this time?
I have none.
No, I'm fine.
I'd like to open the matter up for any public comment. If there are members of the public that would like to come forward on this matter, please come forward, state your name and your address, and present anything that you would like us to consider.
Hi, Ed Harina Jr., 1326 West State, Rhino Linings by SPS. My concern's still the same. The street, the condition of the street is just not adequate for those guys to travel up and down the street. They already have 2 exits to State Street, so I don't see what the difference would be by adding a third. That's basically my opinion. monetarily, I don't think it would monetarily hurt them if they only had 2 exits instead of 3. And there again, the condition of the street just doesn't allow those heavy trucks to drive up and down that street. We don't even allow semis to drive up and down Belmont, and it's a 4-lane paved street. And there again, it all comes down to the condition of the street. It's been very nice not having to pick metal up out of the street. I actually take metal down to BFR Metal sometimes and dump it off because it's very convenient. But for the 4th time, it's just the condition of the street.
Thank you. Is there anybody else from the public that would like to speak on this matter? Commissioners, at this time, are there any other questions of staff or Mr. Chris or anybody that you would have? I'd like to close the public hearing and bring it back in front of the commission.
Okay, I move we adopt option number 1 under Commission Alternatives to accept the findings and sustain the decision of the Planning Commission relating to BFR Metals conditional use permit.
Second.
We have a motion accepting the findings and sustaining the decision of the Planning Commission relating to BFR Metals conditional use permit. All those in favor say aye.
Aye.
Aye. Those opposed, same sign. 3-1 approved. We move to welcome our mayor and commissioner back and forward with the agenda.
I'm sorry, Vice Mayor, you announced 3-1. Was that?
3 to none.
Oh, I'm sorry, I misunderstood.
None, yes, 3 to none.
I misunderstood, I'm sorry.
Thank you, that was my question,
3 to
too.
0. Thank you.
I wondered why you said that.
Thank you. I've taken my seat. Commissioner Haushalter is returned as well, and we'll move on to the consent agenda.
Item 6.1, approve the minutes of July 18, 2011. Item 6.2, award of contract for the 2011 levee, hike, and bike trail improvements, project number 112882, and to perform additional levee trail work between Bill Burke Park and Iron Avenue to T&R Dirt Construction for the budgeted amount of $35,556. Item 6.3, approval of the Key Acres Water Tower logo. Visit salina.org. Right place, right reason, right now, to allow Visit Salina to make payments over the 2-year period for the cost of painting the logo.
Is there any item a commissioner wants to remove from the consent agenda? Seeing none, I'll accept a motion.
Mayor, I'll move that we accept the consent agenda as presented.
Second?
It's been moved and seconded that we approve the consent agenda. All in favor say aye.
Aye.
Opposed, same sign. Motion passes 5-0. Do not have any development business today, so we are on to administration.
Item 8.1, second reading ordinance number 10,610, levying special assessments to pay the cost of repair of sidewalks.
Ordinance 11-10610 was passed on first reading on July 18th, 2011. Since that time, no comments have been received. Is there any public comment today? Seeing none, I'll bring it to the commission for action.
Mayor, I make a motion that we approve ordinance number 11-10610 on second reading.
Second.
It's been moved and seconded that we adopt ordinance 11-10610 on second reading. Madam Clerk, will you please call the roll?
Commissioner Crawford?
Aye.
Commissioner Householder?
Aye.
Commissioner Jennings?
Aye.
Commissioner Shirley?
Aye.
Mayor Angel?
Aye. Motion passes 5-0.
Item 8.2, first reading ordinance number 10,611, amending section 38-1 of the Salina Code, adopting the 2011 standard traffic ordinance. Sub item 8.2A, declare an emergency exists for second reading on the same day. 8.2B, second reading ordinance number 11-10,611.
Ms. Wyatt.
Good afternoon. The 2011 edition of the Standard Traffic Ordinance, or STO, was recently issued by the League of Municipalities. This new edition incorporates changes in state law adopted during the 2011 legislative session. Although the book was just made available to staff, the changes actually took effect on July 1st of this year. For that reason, staff is recommending that the ordinance be approved on first reading, that you declare an emergency exists, and adopt the ordinance on second reading. There were a number of changes made during the past session. A definition was added for lightweight roadable vehicle. Section 13 added the dead red provision, which allows motorcycles to proceed through red lights when the lights don't change after a reasonable period of time. Sections 23 and 25 amend leaving the scene of an accident laws. Section 23 makes failing to stop immediately in some situations a Class A misdemeanor. And Section 25 requires anyone involved in an accident to report that immediately and provide reasonable assistance to anyone that's injured. There were several changes to the DUI laws this year. Those include increasing the 2-hour time limit for obtaining breath or blood samples to 3 hours. Minimum fines were increased by $250. The look-back period for determining if a conviction is a second offense was changed from a lifetime look-back to a 10-year look-back. Commercial vehicle DUI laws were amended to mirror those of the non-commercial DUI laws. Section 30.2 now allows for the use of a preliminary saliva test, and some clarifying language was added to the ignition interlock section. Maximum speed limits are actually covered by the city's standard amendment to Section 33, but this is included to show that interstate highway speed limits have increased to 75 miles per hour. Section 40, which covers passing on the left, adds a provision that relates to passing a bicycle on the left. The seatbelt law was tweaked slightly. It's my understanding this was only changed to prevent cities from altering the fine amounts established by the legislature. Section 194 increases the penalties for anyone driving while suspended, while they're suspended for a commercial vehicle DUI. And in addition to those state law changes, the standard local amendments to the SDO also include this year a change to Section 114.4, which relates to the operation of golf carts. And I will turn that over to Mr. Schrag.
Section 114.4, as you look at it in the ordinance, under Section A, items 1, 2, and 3 were in the standard traffic ordinance. We added Section 4 to prohibit operation of a golf cart on any public sidewalk. We reworded Section B to what we believe is more clear and more appropriate in the community. The SDO provided by almost a double negative, if not a triple negative, that golf carts could be driven to cross a public street, and we feel like that wording clarified it. And then Section C was revised slightly to reflect the current language that allows for that operation from sunup to sundown. So in summary, the local amendment prohibited operation on the sidewalk and clarifies that you may cross a street at a crosswalk with a golf cart. In particular, that alleviates any confusion about the river festival's crossing of Oakdale Drive to get to their storage facilities at the Bicentennial Center.
That summarizes the changes. If there are any questions, I'd be happy to answer those.
I just wondered I'm sorry, Mayor.
Go ahead.
I just wondered on golf carts, does that include the carts that everybody's driving now on that maybe shouldn't be?
There are golf carts, there are worksite utility vehicles, and there are, I believe, what are called scooters and mutts. This is specific to a golf cart. A worksite utility vehicle has entirely different provisions for driving parallel or with traffic on the roadway.
Mm-hmm.
Thank you.
So Section 40 requires you to give a bicyclist a 3-foot cushion when you're going around them?
Correct.
Thank you. That's good to hear. Any other questions?
At 70, yeah.
Yes. Any other questions for staff? Mr. Bankston is going to require 3 motions?
That is the drill, Mayor, yes. It enables the enactment to correspond with state law as quickly as possible. So.
Okay. Is there any public comment? Seeing none, I'll bring it back to the commission for action.
Mayor, I make a motion that we approve on first reading ordinance number 11-10611.
Second?
It's been moved and seconded that we adopt ordinance 11-10611 on first reading. All in favor say aye.
Aye.
Opposed, same sign. Motion passes 5-0.
Mayor, I'd like to declare that an emergency exists for a second reading on this matter.
Second?
It's been moved and seconded to declare an emergency exists so that we may proceed with second reading. All in favor say aye.
Aye.
Opposed, same sign. Motion passes 5-0.
Mayor, I'd like to make a motion that we approve ordinance number 11-10611 on second reading.
Second.
It's been moved and seconded that we adopt ordinance 11-10611 on second reading. Madam Clerk, will you please call the roll?
Commissioner Crawford,
Aye.
Commissioner Householder,
Aye.
Commissioner Jennings,
Aye.
Commissioner Shirley,
Aye.
Mayor Angel.
Aye. Motion passes 5-0.
Item 8.3, resolution number 116843, authorizing the agreement with Salina County and Caw Valley Engineering Incorporated for the purpose of surveying Oakdale Park.
Mr. Stack.
Thank you, Mayor and Commissioners. This is part of the agreement that was signed into effect on March 15th, the city and county entering into agreement to provide a long-term solution to the ownership of Oakdale Park. Resolution number 116807 had in it a provision that the property be surveyed and described legally, which is actually going to be a fairly tall order. So that's it's a piece of property that's been around a long time, and it's the river actually is part of the description, and so there's just a lot of challenging things that the surveyors are going to have to overcome to describe this piece of property. So between the county and the city, they identified Caw Valley Engineering as the qualified source of the survey services for this project. Caw Valley has a local office here and a very good surveyor who has worked a little bit in the area as well with the water park, so has some control established. Much of the time required to develop the contract has been the accurate identification of the scope of services necessary to accurately complete the quiet title aspects of the process leading toward the transfer of insurable title to the city. The only reason I say that is because Greg wrote the majority of this blue sheet, so I am just thought if you have questions, I may just have to ask Greg.
There you go.
But my staff has been responsible for getting the survey and making sure everything's in there to make the survey and the legal description occur. After that, it's going to be a little bit more on him and Mike Montoya to get the rest of the legal proceedings done. But I will, I guess, entertain questions at this time.
You sound really insecure
Survey?
when you say that.
Yeah, anything survey related?
Any questions for staff?
Just with this administrative assistant 2, what is that? Does that mean 2 at 34 an hour, or is this some special title for administration? It seems like a lot of money for an administrative assistant. $34 an hour? I'd like to be an administrative assistant.
That typically has the benefits and multiplier in it as well for the consulting firm. So I guess that's.
These are fees submitted from the firm
From Caw Valley.
proposing to do the work.
Mm-hmm.
I mean, it just seemed like a lot of money. They're all new to me, so.
Yep.
Still.
Typically, you'll see about that for
Is that
most
right?
of our engineering consultants. Yeah, and we can ask. I
Don't
want to
don't.
bring up the administrative assistant, but
yeah,
I don't know if they make
I
that
didn't know what that
much.
2.
That's what they charge out at.
Yeah,
so
I
you
just
know
didn't know
how
what
works.
that 2 at the end was. I thought maybe that meant, I could see that $17 an hour for 2 people, 34.
No, that's just their actual title. There's a 1
That's
and a
their
2
title.
and a
Okay.
senior and all those kind
Okay.
of titles. Yes.
Okay.
Any other questions?
The key thing I didn't mention was that we're splitting 50-50 between the county and the city.
Sure.
Just make sure you do that. Okay.
So, Mr. Bankston, has the court action been filed, or are we waiting for this to be complete before we start that?
It'll be necessary for this to be completed.
Okay.
And that's why we have been so concerned. We certainly hope we're getting it right in terms of that scope of services, as you might imagine, so that we don't have any issues to go back for further work. But as you can probably, as I'm sure you can see from that aerial overlay, there are some really interesting, I mean, the old town was platted as though the river were not there.
Yeah.
And the river has moved. So between those two aspects, it's generally a fairly traditional situation until you get into those platted lots and how we properly handle actually the remnants that will lie on both sides of the river, as well as that area coated in green, which will ultimately be part of the city's holdings, and simply has not historically been dealt with by way of survey, platting, anything to this point. So we're hoping that we've anticipated all of the potential circumstances as well as we can, but that will be necessary in order to both describe it for purposes of the court proceeding. And as you might imagine, Mid-Kansas Title is doing the title work for the city. I say for the city, it's for the city and the county. We obviously will be the insured title holder ultimately, and we've been consulting with Bob Wasco as well to make sure that this will provide him with the information he needs for the title work as well.
So it's not too late to back out, is that what you're saying?
We'd rather you not do that at this point.
Any other questions? Thank you.
Thank you.
Is there any public comment? Seeing none, I'll bring it to the commission for action.
Mayor, I'd like to make a motion that we approve resolution number 11-6843, authorizing an agreement with Salina County and Call Valley Engineering, Inc. for the proposed survey of Oakdale Park.
Second the motion.
It's been moved and seconded that we approve Resolution 11-6843. All in favor, say aye.
Aye.
Opposed, same sign. Motion passes 5-0.
Item 8.4, ratifying the decision from the July 8, 2011 meeting in relation to the 2011 concrete pavement rehabilitation project number 112853.
Go ahead, Mr. Stack.
I believe this is me, yes. Last week, there was, on the actual agenda, under the consent item, we had option 2 as our recommendation, and we put option 1 on the consent agenda. So I guess I just wanted to come back and talk about which one we'd like to do, and we can do either one. It's just we feel like we really received good bids for concrete work at $35 approximately a square yard, which was $5 cheaper than Marymount even, and Marymount was a pretty good bid. So we felt like with the budgeted amount of $250,000, we thought we could go a couple more blocks on Belmont and get some much-needed concrete work done. So that would be the hope, but it's also, we can do $191,000 worth too. It's not a real big deal, but it was a fair bid, and consistent with Rod's comment of me spending down the budget as much as I can, that was my hope. More work for less dollars, we hope. Thank you. Or I'll entertain questions at that.
So we just need to ratify what we've already done.
Yeah, and just, I guess, clarify that it was option 2 for read, I guess have somebody read option 2. And do they have option 2?
We do have
They do,
option
okay,
2.
great.
Dan, there was the confusion last time, what was on the agenda versus what was in the blue
Correct,
sheet.
yeah, the blue sheet was correct. Just the
Just
agenda
one minute.
consent item didn't have the correct dollars in there. So she reads, I believe that gets read as a different amount, and so it's caused confusion with finance thus far.
Maybe just a motion as it's set forth in option 2 on the sheet we have. Okay.
Would work for me.
I think that'd be fine.
Okay.
The dilemma that Finance pointed out was in the effort to utilize the consent agenda, you had a consent item
That
that
was
happened to
read
have 2 options.
Oh,
So,
okay.
It was just clarifying which of the 2 was truly your intent.
Okay. Any other questions? Thank you.
Thank you.
Is there any public comment on this item? Seeing none, I'll bring it to the commission for action.
All right, I'd like to make a motion that we ratify the decision that was made in the July 18th meeting, in particular item option number 2 as presented, with the intent of utilizing the full amount of the budget money, stretching it as far as we can.
I'll second that.
It's been moved and seconded that we ratify the decision from July 18th, 2011 in relation to the 2011 concrete pavement rehabilitation project number 11-2853. All in favor say aye.
Aye.
Opposed, same sign. Motion passes 5-0.
Mayor, at this point in time, I'd like to make a motion that we move into executive session. Looks like for 45 minutes to discuss with legal counsel matters subject to attorney-client privilege for reason that public discussions of those matters would waive the privilege and adversely affect the city's interest in the matters, and for the purpose of discussing matters pertaining to non-elected city personnel for the reason that public discussion of that matter would violate the privacy rights of the non-elected personnel involved, and reconvene at 5:50 p.m.
Second.
It's been moved and seconded that we recess into executive session. All in favor say aye.
Aye.
Opposed, same sign. We are in executive session. Any action when we're complete?
We don't expect that, no.
Okay.